So one of the most important issues that characterize the sordid mess that CSD has become are these measures Q, R, and S. You may have seen them on the petitions, you've seen them mentioned in some of the social media posts, but a lot of people don't really know what's behind them or what the issue really is. Well, these were covered in two grand jury reports that were issued in 2024, but I'll give you a little bit of background here for those that haven't come up to speed on those. So when a new park or any CSD asset is created, there needs to be a funding mechanism set up to provide maintenance for that park. If there's no fund to provide watering and lawn mowing and landscaping and maintenance services, then the park doesn't become viable. So there always has to be a funding mechanism to go along with the creation of the park. The mechanism that they use most frequently are these landscape and lighting assessment districts. So this is a cluster of homes that are assessed an additional property tax on their rooftop in order to put into this pool of money that will provide maintenance for a park that's local to them, that they feel that is going to be used mostly by that cluster of homes. So there are LLADs spread all throughout El Dorado Hills, and likely you're funding a neighborhood park or maybe in some cases a regional park. And so these LLADs are set up, and every year they have to go through a process that requires some sort of outside contractor, a consultant, to evaluate what is the benefit that each of these homes in this, a certain distance away from the park really should be paying based on the benefit that they're getting. All seems on the up and up, and that's the way it's done throughout the state and throughout all the other lighting and landscaping assessment districts. Unfortunately, on a couple of these neighborhood parks and developments, they have strongly objected to the rates at which they're having to pay for the maintenance of these parks, primarily Heritage, Blackstone, and Promontory. The problem with Heritage was inside of their gated community, they've built pickleball courts, tennis courts, bocce ball courts, a park, and the residents at Heritage pay for those amenities. CSD ended up building a public heritage park that has the same exact amenities. They have pickleball courts, tennis courts, a bocce ball court, grass park areas, and a playground. But they're assessing Heritage, again, all the local residents to this heritage park for the maintenance of that park. That duplicates all the amenities that they already had. So there's a real concern about who's really using Heritage Park and who should be paying or who should be assessed for the maintenance. The Heritage folks said, we're willing to pay a certain amount, but you've completely assessed the wrong people. We've got people coming from Cameron Park, from Placerville, from Folsom, all playing pickleball. And they're not part of the assessment at all. They're not even part of the LLAD. So it's very unfair. So they protested this over multiple years and really got no response from the CSD. There was no negotiation. CSD was standing completely behind the assessment engineering report that came from their contractor. They eventually put measures on the ballot to repeal their assessment. Getting no satisfaction from CSD, they went straight to the ballot, and the voters voted almost unanimously, almost over 90% voted to repeal their assessment that they felt was unfair. And CSD has continued to ignore this. They've hired very expensive outside counsel that have said for various reasons that these ballot measures are unconstitutional or illegal or, again, making up excuses. But that's not the way these ballot measures work. I mean, Proposition 218, a California statewide statute, says that the voters can vote away and have to vote themselves in to special assessments like are being applied to these LLADs. And to ignore these ballot initiatives that have passed is completely unethical for CSD to continue doing. And what they're doing is they're paying these very high-priced lawyers to give them the news that they want to hear. They're paying the lawyers to fight the public. So you're being taxed to pay for these lawyers to tell you that the assessments you don't want to pay are illegal. It's complete nonsense. And so this is really at the core of things. The issue with Promontory is very similar. They have annexed a regional park, Promontory Park, into a very localized LLAD and getting a small cluster of homes, relatively small, to pay for a park that has sports leagues, soccer leagues. It's got people coming from Folsom and all over the western part of El Dorado County to use Promontory Park, but all of the costs for maintenance are being applied to the homeowners that were given Calithia Park, a much smaller and more of a neighborhood park, which is totally fair to probably assign the assessment to them, but not Promontory Park. So they've objected. They use the same exact ballot measure process to go remove their LLADs for Promontory Park. And again, CSD just chooses to ignore it, ignore the will of the voters, ignore the election code and the California State Constitution on how Proposition 218 was designed to work. Blackstone has an issue with their neighborhood park as well and the justification for their assessments. So these three different neighborhoods on three different park issues represented in November 2024 these measures QRS, all which passed by wide margins and are being completely ignored. And so this is one of the biggest reasons for the recall. Now, further complicating the matter, and this almost boggles the mind, but these engineering assessments, these reports that justify the LLAD assessments coming from this engineering firm are really very, very questionable to begin with. I actually spent hours talking to the assessment engineering firm about their methodology, about where these numbers are coming from, about how they're applied to the property tax rules and assigned to an individual homeowner. And it is very sketchy at best. It is what it is. I mean, it's a widely accepted practice to do it this way, but for a lot of reasons, it places unfair burden on the wrong homeowners. The details of which are laid out in the grand jury reports, even a grand jury report going back to 2021, 2022. But that's why there's so much objection. I mean, the methodology for the engineering assessments are questionable to begin with. Now, further complicating the matter is the old general manager for the CSD unethically and likely illegally went to work as a consultant for their engineering assessment contractor, creating a complete conflict of interest. And he eventually had to leave the CSD under kind of a shroud of mystery, but nevertheless, he had to resign probably because of that conflict of interest. But the engineering assessment reports that come out annually have to be certified by the CSD. There's a period of time where the homeowners can object to the engineering report. They can say, hey, this is unfair, and then CSD can take that public opinion in, and after that period of public input, they will certify the engineering assessment report, and they send it up to the county. And then the county will bill the homeowners on their property tax bills. So that's how this works. The county is actually responsible for applying the the assessments onto the property tax bills. Well, because of this conflict of interest of the prior GM, nobody was willing to certify the assessments for 2 years, and so they sent the requests for the assessments up to the county without a certification coming from anybody at CSD at all. It could have been done by the GM, it could have been done by an acting GM, it could have been done by probably the board members as a whole, but nobody was willing to do that. So they sent it up to the county without certification, knowing that there was contention over these assessments at these 3 neighborhoods at least, if not wider. So the county did the right thing and said, if you can't certify these assessments as being accurate, I can't put them on the property tax bills. They can't be responsible for the problems that they're causing, and because the county really is uninvolved in what these assessments are, or where they're coming from, or even have any relationship with the engineering assessment firm that's trying to calculate them. So the county said, sorry, we can't assess these without certification. So I don't know what the exact amount is, but this cost CSD, I don't know, 1.2, 1.4 million, a lot of money over 2 years. They were lacking the funds that they needed to maintain parks throughout El Dorado Hills, not just the 3 neighborhoods. So they had to pay for the maintenance out of the general fund, which further complicated their finances. But their next response, rather than just figuring out how to get this certified and standing behind the assessments with their contractor, they turned around and sued the county. And they said the county is required to make these payments. And now we're going to court. There's been no real attempt to try to settle this, to try to reach some sort of negotiation on who is ultimately responsible to stand behind these questionable assessments. And the trial was moved to Placer County to remove the bias from anybody in El Dorado County. So the trial is due to begin this summer in Placer County, and without some negotiation or reasonable settlement or agreement between the county and the CSD of how this process is going to work, this is going to cost hundreds of thousands of dollars to the residents of El Dorado Hills. And you're paying for the lawyer fees on the El Dorado Hills CSD side and the county side. I mean, this is completely nonsense. And the county is frustrated that there hasn't been more of an attempt to try to reach out and discuss this. CSD is standing behind its lawyers saying, oh, these things are unconstitutional, the measures are unconstitutional, the assessments come from a qualified engineer. But they caused the problem by not being in a position to certify their own assessments based on this conflict of interest that was very unethical by the former GM. And it just goes on from there. So the money that's wasted on legal fees, the inability to settle this litigation without going, to trial, that's very expensive, and the ease with which they pawn off all of these, now over $1 million in legal fees over the last 12 months to the homeowners and the public and the citizens of El Dorado Hills is completely unconscionable. So anyway, I hope that helps explain what's going on with these questionable assessments, the litigation with the county, and these measures QRS that are the source of so much contention with so many of the residents here in El Dorado Hills.